Good afternoon, and I first want to thank all of the individuals involved in organizing the conference. For a non-Belizean like me, it is incredibly exciting to have the opportunity to present my work to a Belizean audience and have you respond to my analysis and ask me hard questions, maybe nod your head, maybe a little skeptical. So I'm very happy to be here. The title of my presentation is Territorializing Claims, Performing Sovereignty in Belize. I'm an anthropologist by training, and so I'm taking an anthropological approach to some key ideas that are probably more often talked about by political scientists. There are a couple key ideas or concepts that I want to introduce at the beginning. The first is sovereignty itself. So sovereignty is defined as a form of authority or control over people and territory that is ultimately grounded in violence. Scholars of sovereignty, in anthropology at any rate, do not take for granted that sovereignty simply exists because you have a state, a government. Instead, we look at sovereignty as something that has to be performed in order to exist. So this raises a couple obvious questions. If sovereignty has to be performed to be brought into existence, then what practices are involved in bringing sovereignty into existence? And a second question is, who performs these? It seems obvious that it would be the state who is performing these practices, but my analysis suggests it might be more complicated than that. There's often a gap between the ideal of sovereignty and the way it might actually be practiced. Scholars typically distinguish between internal sovereignty and external sovereignty. So internal sovereignty involves a sovereign who controls their own territory, their own population, who creates laws and has the authority to enforce those laws, including with violence if necessary, arresting people, incarcerating them. External sovereignty, on the other hand, involves the control of external borders of the sovereign's own territory, to keep people from other territories out, and to maintain control of that territory. So the contemporary world is divided into sovereign nation states who recognize no authority over them. With no authority above the sovereign states, it raises a question about how international law is even possible. National law is clearly possible. The state makes laws. If you break them, the state can arrest you, try you, imprison you. But in the international context, where there is no power that can enforce international law, and where sovereign states can't be made to do anything, how can there even be something that we might call international law? And the answer is that sovereign states are bound only by laws that they consent to comply with. Okay, so this creates a situation of legal pluralism, the second key concept that we'll come back to. Legal pluralism is a situation where there are multiple legal systems in play at the same time in the same national space. So in this case, the simplest configuration of that for Belize is Belizean domestic law and international law and the way that they might interface. So I want to look at 4 examples of the performance of sovereignty in Belize to look at these questions of how sovereignty is being performed and by whom. The first one involves incursions across the western border. So the government has established protected areas across a wide area of Belize, and the creation of protected areas themselves is an act of sovereignty. However, the government has not then governed those protected areas very closely itself. It has, in most cases, delegated responsibility for managing and patrolling those protected areas to conservation NGOs. So it's really NGOs, non-government organizations, who are on a day-to-day basis performing sovereignty in protected areas. When the protected areas are along the border, this gets more complicated. So, for example, in the Q'eqchi, you had the Friends of Conservation and Development patrolling protected areas that they were responsible for that run along the border, often encountering Guatemalan civilians who were illegally present in Belize, illegally extracting resources or clearing forests in order to plant. This is clearly a violation of Belizean law and also a violation of Belizean sovereignty. And when Friends of Conservation and Development made this public, it elicited strong public outcry demanding that the government itself exercise visible forms of Belizean sovereignty along the borders. So we have, as a result, joint patrols between conservation NGO rangers and the BDF and Belizean police, so that the BDF and the police can perform sovereignty when the patrols come under fire from Guatemalan civilians, which, as we know, has happened way too often. So we have then a situation where there's kind of joint sovereignty being performed by these patrols. The second example I want to talk about involves the incursions on the southern border. So after the 2008 special agreement was signed, the Guatemalan military became much more belligerent in the south than it had been before. It was basically attempting to perform sovereignty over the Sarstoon, over the whole of the Sarstoon, in areas claimed by Belize. Basically, it had to, if it hoped to have a case at the ICJ. It couldn't be a good neighbor respectfully observing the boundaries that Belize claimed and still have a case. And so I understand these actions to be an effort to perform a sovereignty that it's claiming beyond the boundaries that are currently that we recognize for Guatemala. The government of Belize has responded to these Guatemalan incursions with diplomatic notes of protest. Guatemala has answered those notes with the assertion, we don't recognize Belizean borders. Now, the expert opinion that the Belizean Bar Association has just received on the matter of the ICJ suggests that the government's sending notes of protest to the Guatemalan government are sufficient in international law to serve as the exercise of sovereignty. But my impression, and this is from reading Belizean newspapers, keeping up with the evening news programs, occasionally seeing the morning programs, my impression is that that has not been a satisfactory performance of sovereignty from the perspective of many Belizean citizens who wanted a more public, visible performance of sovereignty in standing up to Guatemala. So what we've seen is a more public, visible performance of sovereignty with regard to Guatemala, but not by the government, rather by citizen organizations. So we've had the organization of the Belize Territorial Volunteers, which has attempted to transit all of Belizean territory, to go all the way to the borders to make sure that it's clear that they're claiming land all the way up to the borders, to mark the borders physically with their bodies by being there, to plant Belizean flags there, sing the anthem. So there's an effort then to assert sovereignty, perform sovereignty, make it visible in public, that is not being carried out by the government. Instead, the government has continued sending protest notes to Guatemala, particularly about the harassment and even imprisonment of Belize territorial volunteers. But it's also warned the Belize territorial volunteers to stop going to the border to avoid provoking Guatemala. Okay, so we've got a kind of strange example here where it's Belizean citizen organizations that are aggressively performing national sovereignty in a place where the state is very wary of having that happen. The third example is the Maya lands cases. Litigation over the Maya land claim reveals some constraints on the government of Belize's sovereignty that result from the existence of a situation of legal pluralism, the operation of more than one legal system in a single space. The government of Belize is bound by the laws it has created, so the Belizean Constitution. The government of Belize also consents to be bound by the common law, the legal system inherited from the British and shared across the Commonwealth. And the government of Belize has consented to be bound by certain international treaties. The most significant for this particular set of cases involves the American Declaration on the Rights and Duties of Man that everyone who joins the OAS must agree to, the International Convention on Civil and Political Rights, and the International Convention on the Elimination of All Forms of Racism. So it's back in the mid-1990s, I guess that's 3 decades now, that the Maya launched a legal petition in the Belizean courts, which wasn't acted upon. So the case was then taken to the Inter-American Commission on Human Rights. The Inter-American Commission decided in favor of the Maya largely on the basis of international laws to which the government of Belize had consented. The Commission also identified another legal system besides international law as the source of indigenous rights to lands and territories, and that system is Maya customary tenure. According to the Inter-American Commission, Maya communities' practice of customary tenure via the alcalde system creates property. The government's failure to treat this property in a way that is equal to the way it treats property created by Belizean law is discriminatory. And that discrimination violates the international laws by which Belize has agreed to be bound. Okay, so we've got a situation now where we have an additional layer of legal pluralism with Maya customary law in the mix with international law and Belizean national law. So after losing in the Inter-American Commission, the government failed to implement the decision, which could not be imposed upon it. It was only advisory. They came back to Belize and began a series of cases in the domestic legal system. In the Supreme Court, the Appeals Court, and finally the Court of Last Resort, the Caribbean Court of Justice. During the litigation, the government defended its sovereignty in 2 primary ways. First, it insisted that the courts should apply the common law rather than international law. Remember, the Commission had decided against the government on the basis of international law. It thought that it had a better argument from the common law, so it wanted the courts to apply the common law rather than international law. Second, it argued that the Maya claim to collective property threatened Belizean sovereignty because the Maya, if given collective title, could simply take their land, secede from Belize, and join Guatemala. Unfortunately for the government, the courts did focus very deeply on the common law in their decisions, but they determined that the common law also recognizes Maya customary tenure. The government has also asserted in taking its case to the public that Maya customary tenure is discriminatory. Everyone, they say, should have the right to live wherever they want. Realistically, under Belizean law, people cannot live wherever they want. All property owners can prevent other people from living on their land. Not only that, all property owners can expect the government to back them up in evicting people from their lands. So it's not really a true statement that people can live wherever they want in Belize, with the exception of possible collective Maya territories. The fourth example involves the case of Rupert Miles, Malaysian law, and Maya customary tenure. So as I'm sure you all are aware, Rupert Miles was a Creole gentleman who built his house on a temple mound in Santa Cruz, which violated Belizean antiquities law and violated Maya customary tenure practices. Santa Cruz leaders requested that the government and police come to enforce Belizean law by removing Miles' house, but the government took no action. The Maya then used alcalde system procedures to seek a resolution with Miles, but Miles threatened violence, and Santa Cruz leaders restrained him, again using principles of Maya customary tenure. Images of Miles handcuffed went viral, causing a huge outcry in Belize. The Prime Minister denounced the Santa Cruz actions, and people were very anxious to know what was behind this and very angry about the images that they were seeing. A few days later, the government dramatically performed sovereignty by engaging in a nighttime raid in the village of Santa Cruz, where village leaders were arrested, taken to jail, and a few days later charged with assault. So we have a dramatic state performance of sovereignty in Santa Cruz, which is kind of the first dramatic performance of state sovereignty that we've seen in these examples. Much later, however, all charges against Santa Cruz leaders were dropped. Miles himself, who was clearly in violation of Belizean law, was never arrested or charged. So by way of conclusion, I want to argue that the government's performance of sovereignty has been extremely selective. Sovereignty, in many of the examples that I've looked at, has often been performed by non-state actors. So NGOs perform internal sovereignty by managing and patrolling Belizean protected areas. In the West, publicity surrounding Guatemalan civilian incursions into protected areas led to a shared performance of external sovereignty between government forces and the NGOs. In the South, the government has not dramatically performed external sovereignty in response to Guatemalan military incursions. Instead, the most dramatic performance of external Belizean sovereignty in the South is carried out by Belizean citizen organizations, such as the Belize Territorial Volunteers. Part of what I understand to be going on here involves this context of legal pluralism. So the Belizean national context involves international law, the common law, Belizean national law, and Maya customary tenure when it comes to the Maya lands cases. So you have four different systems interacting, all of which have some different rules. And the interfaces between them are not easy. It appears that the government is concerned in this context to try to delegitimize Maya customary tenure practices, which have been recognized by domestic and international judicial bodies as the source of Maya land rights. Instead, the government attempts to assert the supremacy of national law in this kind of legally pluralistic context. So the government has dramatically performed internal sovereignty in the rest of Santa Cruz leaders while they were enacting or for enacting Maya customary tenure. yet it failed to perform internal sovereignty in response to mild violations of Belizean law. So what I see going on here is efforts by the state to position national law as more significant than Maya customary tenure in relation to decisions based on the common law and international law. Thanks very much.